My opinion is a little similar and little different with other judges. I think harmonization of IP law is not required, but desirable. Korea is not part of an economic community like European country. Korean market is separate from those of neighboring countries, and as you know, IPR is inherently bound by the territoriality principle. However, as we covered in the last meeting, the global online market has grown dramatically. The demand is growing for better harmonization of IP laws. I want to talk about the Korean practice about foreign cases. According to the Supreme Court of Korea decision, whether or not to register trademark will be judged in relation to a relevant good and service in accordance with the Korean Trademark Act, and will not be bound or affected by what happened to the mark in other countries that has different laws and languages. In particular, we cite this precedent when it comes to different conclusions from other countries. However, in some cases, especially cases where one party submitted foreign cases as evidence or reference supporting each position, a foreign case may be introduced in Korean judgment as one of the factors of favoring to one party. In my case, even if a lawyer don't claim foreign cases, sometimes I look for them myself. I had a case of Botox. You know Botox? It's a magical substance called wrinkle treatment. It's a very popular Korea.
Is it magical?
Yeah. The main issue of the case was whether Botox was a generic word or not. At that time, it was very difficult to decide. So I asked my powerful senior researcher to collect foreign cases on Botox. It was really helpful. Although I did not mention foreign cases in my decision because the lawyer don't claim the foreign cases. I think the question or whether or not to cite foreign cases depend on the marketplace of trademark. If the country's market condition is similar to Korea's, the foreign precedent is valuable, but in the opposite case, may not be very helpful. And lastly, I want to talk about the harmonized model law on IPR. Of course, harmonized model law on IPR will be really helpful. However, it seems that the result will vary greatly depending on who makes the model law. And I wonder if it will be easy to make a model law with the support of many countries. I had some experience to attend the WIPO Standing Committee on Patent Law as a legal advisor. At that time, we tried to make a harmonized model law, a substantive patent law treaty. But you can imagine what kind of impossible trouble we faced. Coordinating the interest of many countries was not easy, extremely difficult and time-consuming, tedious and boring, but very important. Thank you.